I mean, sometimes tenants just do the wrong thing. They can get served with all the right paperwork, an N12, in this case, a notice called an N12, that says that, hey, I've sold the property, they're going to be living here, they've sworn an affidavit that they'll live here for a year, you've got to go. And the tenant might just not leave, right? And if that happens, well, now the seller has to go take them to the landlord-tenant board, and as we discussed, that could take many, many months, and it can blow things up. And an interesting aside, a lot of people don't know this, but sellers in that circumstance, because I get this all the time, a seller will come to me and say, hey, I've sold my property, but the tenant is blowing up the deal because they refuse to leave. Can I sue the tenant? Can I sue the tenant for blowing up my deal and causing me all these problems? Believe it or not, the answer is no. There's case law that says that there's nothing wrong with a tenant exercising their right to go to the landlord-tenant board. Even if they know they're going to lose, there's nothing wrong with them, dragging their feet and waiting until they get their day in court at the LTB. And so this case has actually been tried before, and landlords and sellers have lost. So it's very, very frustrating. We live in a very pro-tenant province where the balances are very skewed towards protecting tenants rather than landlords.
So if a buyer is buying a tenanted property, if property is not closed on the closing day, so you mean to say that buyer can walk away from the deal?
In their agreement of purchase and sale, it specifically says, and this is the boilerplate language, that they're buying it vacant, that vacant possession shall be provided. And then they discover that on closing, it's not vacant. Yes, they can walk away from the deal. They can basically terminate the agreement, and they should be able to get their deposit back. Now, as you know, that can get a little bit complicated, right? Because the only way to get a deposit released to anybody is either an agreement in writing, the transaction goes through, obviously, or somebody goes and gets a court order. And getting a court order can be expensive. They might have legal rights, but enforcing those legal rights can be sometimes difficult and expensive.
If the seller is not signing the mutual release, so they have to go through the court to get the deposit back?
Yeah, unfortunately. And so we've dealt with that on both sides, by the way. Sometimes we're acting for sellers and sometimes we're acting for buyers.
Right.
But if the two of them can't work it out with a mutual release, then yes, the only way to get the money released to anybody is going and getting a court order.